Welcome to Fasken's 16th Annual Global Mining Group Seminar Series. My name is Virginia Schweitzer, and I'm part of the Fasken Global Mining Group and also a partner in Fasken's Ottawa office. Today's session, Leading the Way or Falling Behind, Compared Allied Critical Minerals Investments Control Regimes. In the seventh of our series of our 12 seminars this year. For those watching online, there is a link to our seminar series beside the video window. And for those in the room, there is information at our registration desk. As you view the info slide on the screen, I'd like to provide a land acknowledgement. At Fasken, we have embarked on a journey of reconciliation, guided by our Reconciliation Action Plan. As part of this journey, we believe it is important to acknowledge the land and the people who have called this land home since time immemorial. Today in Toronto, we are gathered on territory that has been the home of many nations, including the Wendat, the Anishinaabe Nation, the Haudenosaunee Confederacy, the Chippewa, and the Mississauga of the Credit First Nations. Toronto is covered by Treaty 13, signed with the Mississaugas of the Credit and the Chippewa. We appreciate living and working here and recognize the importance of working to advance reconciliation between Indigenous and non-Indigenous people here and across Canada. I would now like to introduce Andrew House, who is a partner at Fasken in our Ottawa and Toronto offices. Andrew?
Thanks, Virginia. I had intended and hoped to be there with you all this morning, as is the proper role of a moderator. And unfortunately, I've been laid low with illness. It's probably best that you all be kept separate from me, especially our esteemed panelists. And I appreciate your indulgence in that regard. If I simply topple over, it's not from emotion or sadness about foreign investment. It'll just be illness related, and another panelist will carry on. Look, I'm delighted to be here, even virtually, with this group that I've gotten to know over the last few meetings with them on the topic of foreign investment, which is near and dear to the heart of, I will say, many in the Canadian and international business world who look at Canada as a destination for capital, a safe destination, a reputable destination, and a place where you can do business. And I know that there have been in recent years questions raised about the predictability and the lack of welcome to foreign capital in Canada. And what we'll do today is unpack a little bit of that history just at the outset, and really then embark upon a compare and contrast about what allied regimes are getting right. Let me just quickly introduce our panel. We'll first mention Clinton Yu, who is an international trade attorney who advises clients on compliance with U.S. trade and investment laws. Clinton's practice, when you read it on his website, it's intimidatingly broad. Clinton, you're clearly the guy to go to in D.C. Everything from CFIUS work across export controls, tariff work, including the famous 232, countervailing duties and country of origin, to name just a few, along with forced labor and supply chain. So that's obviously a very broad practice. And I did note that you were listed as a rising star in international trade. I know that wasn't yesterday, but it certainly merits recognition. And thank you for being one of the people that we come to see when we're in DC. And thank you for being here today. Secondly, let me welcome from literally the other side of the globe, Clementyne Rawlyk, who specializes in inbound investment and complex Australian cross-border mergers and acquisitions. She is a trusted legal advisor to her clients working across several industries, including healthcare, digital, technology, manufacturing, and mining. And Clementyne, obviously, you do a lot of the same regulatory work that Hui Do and I do, which is a both general approach to investment control, and then diving general in terms of the industries, diving deep on that particular issue. So thank you for being with us here today, tonight. We're across so many time zones here that it would be hard to track whether we should be breaking out the coffee or wine. You won't be judged just because people are having breakfast in Toronto. Thirdly, Alastair Mordaunt has more than 20 years of experience as a private practitioner and regulator across 3 continents, giving him a deep understanding of working effectively with regulatory regimes to achieve successful outcomes in transactional and investment matters. He is a partner in Freshfields' UK antitrust, competition, and trade practice, but has worked in and is certified in a variety of markets, worked in Brussels, Hong Kong, and DC previously, and has time in government as well, which is such a valuable thing to bring to a regulatory practice and something that we certainly look for at Fasken. So thank you, Alastair, for being with us today. Coming from the UK. And finally, but certainly not least, my partner at Fasken, Hui Do, who is the co-leader of our competition marketing and foreign investment group, and has been, since I came to Fasken, my go-to person on truly difficult issues, particularly around basic jurisdiction, which, as we will talk about, there's nothing basic about it when it comes to foreign investment practice. This is often the make or break of a transaction. Hui has extensive experience advising foreign clients, including state-owned enterprises, on economic and national security reviews under Canada's Investment Canada Act, which you'll hear about frequently in this presentation. Hui is predictably ranked in all the predictable places, and I won't embarrass him by listing them all, but Hui, I thank you for being here today and for your help with my practice over the years. Let me just recap what it is we're trying to tackle here today. And I'll just briefly restate the description for our event. Global investment capital flows like water. It takes the path of least resistance around and away from restrictive or unpredictable regulatory regimes. You'll often hear investors say, I don't care that it's difficult. I'd like to know that up front with sufficient specificity that I know whether I should try or quit while I'm ahead. And this means an awful lot to people who have dollars to spend and have to make very fateful choices about where they spend those dollars. Investors often approach us believing that they are spending dollars in South America or in Africa, only to find out that Canada will take a very keen and very active interest in how and where those dollars are spent because of a declared declaration made by Canada. Between Canadian jurisdiction and that offshore property. We'll talk a lot about extraterritoriality today as well, at least as we would define it. Our central purpose is comparative in nature. Among allies, who is getting investment control right, and how are those countries achieving this? How do our respective jurisdictions deal with challenging but arguably necessary investors? And here, let's speak it out loud. In mining, in particular, often the investors with the bravery to go into a South American or Central American jungle to determine whether there is copper in their hills is a Chinese investor, often a state-owned enterprise or state-influenced, because those definitions run so closely in Canadian law. And so we are often talking about Chinese dollars. I think it's fair to acknowledge for those who join us today from government that we get it. There is risk in dollars that come from countries that don't share Canadian or allied traditions of rule of law or democracy. And I don't want to minimize that for a second. The strongly countervailing force is, of course, what people in the mining industry face on a daily basis, which is, where do I achieve the dollars that will allow me to prove a property? As a retail investor, I don't want my dollars necessarily going into a project of that high risk. And yet I do want Canada and Canadian companies to be able to prove their properties. So those are solitudes that are sharply divided. Let me just briefly address where we've come from in Canada in the hope of setting the table both for our listeners and for our panelists. Going back to about 2022, we saw very modest lithium investments by Chinese enterprises blocked. In one case, the investment, I just looked it up again to remind myself how modest it was, a little over $4 million Canadian. In other words, it would have taken a greater amount from Canada's treasury to pay the salaries of the officials who blocked the transaction over time than it would have than was the value of the initial investment. And that obviously caused people in Canada and the investment community to be taken aback. The property, although it was lithium, was fully offshore to Canada. The rate of ownership was about 14%. Again, the quantum was a little over 4 million, fully offshore. By 2024, things had taken, I think, a turn even further to the worse. There was an attempted investment by a Chinese company in Ecuador, 15% ownership. The mineral in question was copper. It was fully offshore to Canada. It also failed based on national security concerns as defined by the government of Canada. At this point, Fasken began to take questions from a variety of miners about how would we leave Canada for Investment Canada Act purposes if we needed to. And this was, of course, the subject of this event last year, was emigration out of Canada. We've had a change in leadership in our country. We have a new prime minister. He's a very business-oriented fellow. And there is some hope that we may see a more business-friendly investment climate and a more welcoming environment for foreign direct investment into Canada. And so we ask ourselves, is there a chance for a reset? And if we were to reset, moderate, make things more friendly for foreign investors into Canada, including in offshore Canadian nexus properties, what would that look like? We all agree that there are first principles amongst the Five Eyes community. And let me define that for people who are not in the security business. The Five Eyes are the post-war intelligence alliance that exists and continues to exist, thankfully, between Canada, the US, the UK, Australia, and New Zealand. And so you'll often hear reference to the Five Eyes community. That's a community bound by history, by cultural similarities, but by chiefly a very deep dedication to democratic principles, rule of law, free market economics, and mutual and shared understanding of national security. Those last two are in competition. Free market forces, i.e., allowing people to invest where they will and where they may, versus fulfilling the first duty of the state, which is to see to the safety of citizens, both corporate and natural. Those values are in tension, and one of the things we'll talk about today is how to resolve that tension to the extent it can be resolved. Let me move into our first theme, which will allow me to stop talking and actually put some of our experts forward. Hui, I'll turn to you first on our first theme, which is just a comparative primer. And what I'll ask each of you to do is just explain your jurisdiction's foreign direct investment control. As the saying goes, just the facts for now. In theme 2, we'll talk about what really works and what's really broken. Just give everyone a general primer on how things work. And we will start with you in Canada.
Thanks, Andrew. In Canada, we've had our Investment Canada Act going back to the 70s. It's been revised a few times, but we've always had, as long as I can remember, going back that far, a net benefit review threshold. So we have an economic screen in Canada originally. The national security regime only came in 2009, and that's a little new for us. But our focus here is on the national security side of things. So in Canada, if you are a non-Canadian and you're looking to invest in a Canadian business, then you are required to either, if you're over a certain threshold, apply for review under the net benefit test, or if it's below that threshold, you notify the transaction, and you can do that post-closing. The national security regime was superimposed over that in 2009. Essentially, it says the minister has the discretion, once he or she receives the notice of either an application or a review, or a notice or an application for review, to decide whether or not national security concerns are raised. And if so, there is the discretion on the part of the minister and cabinet to invoke and subject the transaction to a national security review. And that review can be fairly lengthy. It can go like over 200 days. So that's kind of the basic framework. The jurisdiction for national security review is a little different than the net benefit side of things. So for the net benefit side, if you are acquiring control of a Canadian business, and Canadian business is defined a certain way, you have to have assets in Canada, a place of operations in Canada, and you have to have employees or independent contractors working in Canada. So all three of those have to be met to trigger the net benefit review. Under national security, you only need one of those three to trigger or at least allow the government to take the position that it has jurisdiction. So it's a fairly broad test. So, a lot of these companies, they may have maybe an employee here in Canada, even though their operations are offshore, or they may have assets in Canada, bank accounts and the like. So that test there for jurisdiction, I think the key that we have to keep in mind is that it's different than the regular test for net benefit. And then oftentimes investor, when they look at it, they say, well, wait a minute, why are we subject to this national security review? But that's the basis. And so that's kind of where we start off here in Canada.
Thanks, Huy. And I know this is an area that you and I have struggled with almost daily since I came to Fasken, and I think a lot of other practitioners have as well. I'll come back on a couple of the points that you've raised, but let's move through to Australia. And Clementyne, you've given us in our preparation a really good overview of what's happening in Australia. One of the things that struck me so profoundly as I was struggling with the Canadian regime is Huy and I were doing a deal that had an Australian element. And we were chatting with Australian counsel, and they casually mentioned that, well, below 10%, we don't really care. And I sort of had to lean forward into the screen and say, I'm sorry, you have a threshold below which you don't care. And they quickly corrected and said, well, it's not that our government doesn't care. It's that there were limitations on how much we can dedicate to the examination of investment. And Australia has set some thresholds. And I was astounded because that seems remarkably sane and practical. And I'd love if you could tell us more, including correcting me on how sane and practical Australia is.
Thanks, Andrew. So, yeah, I guess maybe just stepping back, Australia obviously regulates foreign investment. Our regime has been in place since the 70s as well, and it operates across two broad tracks. So we've got the general FDI regime that's been in place since the dawn of that regime. And then we've got a national security regime, which was only introduced back in 2021. So interestingly, critical minerals businesses and investments in mining don't yet fall generally under the national security regime, which is new. So those types of investments are governed under our general regime. And yes, investments in mining can be caught in a number of ways under the general regime. You've got the general share, a basic threshold test, which is 20% that applies to all investments into Australia, regardless of the sector. And then you've got monetary thresholds which apply. And those are relatively high other than for government investors, which you touched on earlier. But yes, you're right. So the other way that investments in mining are caught under the regime in Australia is we do have a special category of investments in what we call land-rich entities. And so that's essentially an entity where more than 50% of its asset value is tied up in land, and mining and production tenements are land for that purpose. So where you've got a land-rich target, yes, the government regulates investment where, the stake that's being acquired is 10%. So we don't generally regulate investments below that 10% threshold, other than where it's not quite true, because where you've got an investor who's acquiring a less than 10% interest, but that's going to be coupled with some kind of control or influence right, then you would fall within the regime, and that sort of threshold test, falls away. And for mining companies, so where you're a land-rich entity because you've got, mining tenements, basically that's a $0 threshold. So a $0 threshold to acquire more than a 10% interest. once you're in that world, you've applied to the regulator, they screen the investment from the viewpoint of whether it's contrary to the national interest, which is a little bit. So I guess that the starting position, and it's interesting when you speak to our regulator, they always go in with a presumption that it should be approved unless they find that it's contrary to Australia's national interest. So that's always helpful to understand. And obviously then you've got foreign government investors, though, which have a $0 threshold as well for investments above 10%. But again, where they're going to acquire a control or influence, that's a stake of an investment of any stake that can be caught. And I think control and influence as well is quite broad. So where we see that often play out is if the investor is going to acquire a board seat or even something, will obtain sort of some customary veto rights over reserved matters that can tip you into having some kind of level of control, where again, sort of then that's any stake can be caught.
Okay. Anything else you'd like to say? I have a couple questions for you on the specifics, and I don't want to test you too rigorously, given that it's getting late for you, but you're doing marvelously. So I'm going to risk this. So I just want to confirm, if a foreign investor that was not government owned, was not in our vernacular a state owned enterprise, wanted to invest in land, i.e., a mining property at 9.9% of ownership, no board seat, no special informational rights, no ability to appoint senior management, that investment could go forward
Correct.
Unrestricted.
Correct.
So this, again, I don't mean to be silly about this. This is shockingly excellent in my view, in the sense that, well, I'll just quote from a journalist, Canadian journalist, great writer in Canada, Niall McGee, writes. He's got the mining beat for Canada's Globe and Mail newspaper. He refers to the phenomenon of struggling to survive the valley of death in Canada's mining industry. Not to be too dramatic, but what he's referring to there is the ability to get through it's not your seed round, but it's the round of financing that takes you through the proving of the property, where nobody wants to invest. No one cares who you are. And if they do care, they find you shockingly risky. And this is where trying to find those investors is so difficult. And it is what brings clients that I have come into contact with reluctantly, in most cases, into discussions with Chinese investors. People don't go out seeking initially Chinese investment. This is in many cases, an investor of last resort, but it's because the Canadian company finds itself in McGee's valley of death. And the idea that you could take on investment up to 10% without interference, in the acknowledgement that if there are these control indicia, you bring yourself right back into jurisdiction. Fascinating and mature, in my view.
It's interesting. We've always thought, we always advising and come up with a lot of angst against our regime from investors. So that's interesting to hear that we might be viewed favourably. The other thing, though, to point out is we do also have a voluntary regime, which does fall under the recent national security part of the legislation, and essentially, what that voluntary, how that works is where you've got an investment that it can include any stake in an entity. You can voluntarily apply to have that reviewed. Now, no one would ever voluntarily apply, but because of the breadth of the sort of circumstances and types of investments that qualify for a voluntary review, the government has published guidance, and it's on the government's website around the types of investments and the sectors in which it would encourage a voluntary filing. Interestingly, for this discussion, and certainly the current government's position is that investments in Australia's critical minerals sector is considered high risk and sensitive. And so investors are encouraged, and the guidance is there encouraging investors who want to invest in businesses involved in the extraction, processing or sale of critical minerals in Australia to seek voluntary approval. We've got a similar sort of call-in review. So where even though you don't fall within the mandatory regime, it begs the question, why would someone want to voluntarily file? It's because the government does have a call-in power to call in for review investments for up to 10 years after they've been taken if there are national security concerns. So, when you do make a voluntary filing and you obtain approval, that would extinguish that call-in power. But having said all of that still, and because that is a relatively recent change, that we're not seeing investors wanting to voluntarily file. So that they are not sort of choosing to, notwithstanding very clear government guidance at present, to voluntarily file, which is interesting.
Hui, can I double back to you and to Canada for a moment to just very briefly talk about Canada's voluntary filing mechanism and why an investor might choose to voluntarily file, compare and contrast to what Clementyne has just told us about the Australian regime?
Yeah, and in Canada, it's interesting because in the old days, we talked about on the net benefit side, you either file an application for review or a notice that if you're below the review threshold. But in those cases, that for national security purposes, that starts the clock on the minister in terms of deciding whether or not to invoke national security. There was a gap because in the old system, there was no way for us to essentially pre-notify if you were not acquiring control. Like, let's say you're making a minority investment in a company. You don't trigger a mandatory filing. So how do you start that clock, right? So there was some ambiguity as to whether or not you could just send a letter into the minister saying this deal is going ahead. But a number of years ago, the change was made to essentially allow for this voluntary filing process. So in other words, if you are not triggering the mandatory filing requirements, but you are in one of these sectors, and critical minerals is one of them, where there could be heightened risk, it's possible to file that notice. And if you file that notice voluntarily, the minister once again has 45 days to decide whether or not to invoke the national security review. If he or she does not, then the transaction, for all intents and purposes, is clear from a national security perspective. If you don't make the filing, the minister has up to 5 years after closing. So it's a little shorter than I think the case in Australia, but there is that risk. Interestingly, in Canada, my experience has been, I think where there are critical minerals involved or sectors where you expect the government to have some concerns, there is more willingness to go in voluntarily because I think people don't want to assume that risk.
So, Alastair, I'm going to come to you on the UK. I will tell you that in my frustration about how Canada's model was evolving, I did come across an article a couple of years back that indicated that our British cousins were consulting with the public, the business community, about how to make the NSIA regime more friendly. I think it's a direct quote. I hope I'm not paraphrasing in an abusive fashion. Literally, the idea had emerged that coming out of the pandemic, things were a bit harsh and that foreign dollars were being dissuaded and that things needed to be more business friendly. Am I making that up? Am I misremembering? This struck me as fascinating versus a Canadian system that was clearly interested in cracking down, particularly on Chinese dollars. I'd love to hear about the UK system from an actual expert, and please disabuse me of any of these misconceptions about how friendly things are in the UK.
Thanks, Andrew. Well, first of all, thanks very much for inviting me to join this fantastic panel today. Look, I think you're not misquoting, and it's true. The UK government is seeking to encourage investment, whether that's domestic or foreign, and they are currently consulting on some reforms to effectively make the process run better for their review of what they would call national security cases, but also tightening areas where they think they should be able to scrutinise transactions. So let me give you a little bit of a potted history, because the regime in the UK is a national security regime, and it's actually very new. It was only introduced in 2022. And before that, there wasn't a general FDI regime or anything like that. There was simply a public interest regime that sat within the UK's merger control regime. And for very specific defined cases, the minister could effectively intervene in a merger review that was being conducted by the Independent Competition Authority and effectively take over the case. But that was very specific and in limited circumstances, effectively related to defence, so defence cases, certain media cases where there was a concern around media plurality, financial stability, which was introduced after the global financial crisis. So essentially, it was a very open foreign investment regime in the UK, and essentially there wasn't a foreign investment regime. And then fast forward to 2022, looking around, in particular Europe, that had introduced a number of FDI regimes, but no doubt also influenced perhaps by our counterparts in the United States and their regime, which we'll hear from Clinton on in a minute. The UK was encouraged to introduce a national security regime. And interestingly, it's not a foreign national security regime, because actually it applies to all investors, including UK investors. So we now have a regime, and it has many of the same hallmarks of the regimes that we're talking about today. There is a mandatory filing element to the regime, and there's also a voluntary filing element to the regime. The mandatory regime focuses on 17 sectors. There are 17 today. I suspect that number's going to change after the reforms, but it's 17 today, and it's relatively clear whether or not the business you're looking to invest in falls within one of those 17 sectors. So in that respect, it's quite a sort of a clearly defined regime. In terms of control, and hearing from Clementyne and about what's the level of investment you need, on the mandatory filing side, you need to acquire 25% or more, or have the ability to block an ordinary resolution of the company, which is probably going to be more than 25% in all likelihood. So essentially, the mandatory regime kicks in at 25%. Nevertheless, to have jurisdiction for the government to look at it, so in other words, if you want to voluntarily file, or they want to come in and investigate on their own initiative, there has to be what they call material influence, and that is a lower level in practice than 25%. It's a term that is known, borrowed from the merger regime. So practitioners are very much used to what it means, even if it's not a specific threshold. In practice, material influence is presumed at 25%, but could be as low as 20 or even 15% where combined with additional governance rights or other factors. So a board seat and 20% or perhaps even 15% could well amount to material influence. So there's a little bit of a grey zone there, but it does mean that if you don't acquire material influence, so let's take Clementyne's example, the one you raised of 9.9%, no board seat, no additional rights, I think you could be confident that isn't material influence, and therefore the regime is not triggered by that level of investment. Just a couple more points, just to sort of by way of introduction. Because the government chose to identify 17 sectors, and critical minerals are what included in that 17. And there's no financial threshold. It means that the funnel for reviews is actually very, very wide. So if you just look at pure numbers, the government typically looks at over 1,000 cases a year as an initial review. And so in sort of merger control talk, that would be a sort of a phase one review, but it only takes a very small number of cases to an in-depth review, or sort of a phase two, what they call a call-in transaction. So they call it in after initial review. And if I look at 2024 and 2025, there were 1,079 notifications reviewed and only 56 were called in for a detailed review, and only 17 ultimately resulting in remedies or blocked. So I like to say the funnel is very, very wide, but actually the number of cases that they scrutinize in real detail and the numbers that they actually then seek to remedy or intervene in some way is extremely limited. So that's the sort of the process that they have adopted. On critical minerals, they fall within a sector called advanced materials. And what's interesting is that there needs to be an activity in relation to advanced materials in the UK. So I think if I take the example you mentioned of a mine in Ecuador or in Chile or wherever it might be outside the UK, it's highly unlikely not to trigger a filing requirement in the UK unless there's a related activity. And again, the activity is actually defined in the legislation, but I don't think it's going to be a bank account. It would need to be R&D, perhaps patents related here that are being created, supplied, exploited in terms of IP. There's got to be something sort of material and something in the UK probably goes beyond just having a bank account, which I think is the example you gave. So it feels to me that the extraterritorial issue that you are raising from a Canadian perspective probably doesn't exist in the UK. And I think therefore from that perspective, the UK is probably a bit more open and welcoming from that perspective. But I'll stop there as some initial comments.
Well, let me continue on with the extraterritorial, when it applies outside your jurisdiction. I find this shocking. It's been such a feature of the Canadian regime. It's been such a controversial problem for investors who wish to invest in a property or in a wholly owned subsidiary of a Canadian company that has nothing more in Canada than any one of the following three. And again, this is not an and test, it's an or test. If you have employees or contractors in Canada of any amount, even one, if you have an asset, including an intangible asset like a bank account, or if you have a simple place of operations, any one of those three will ground Canada's jurisdiction. And sorry for stepping on your toes as our Canadian expert, but this was the issue in the midst of a deal last year that leapt out at me from the UK perspective. We had asked UK counsel, here's the situation. The mine is neither in Canada nor the UK. Is there a problem? No. Not at all. If the property is not here, and Alastair, you've helpfully, I think, given a more nuanced answer that there can be IP or similar, but the answer from the UK perspective was no, unless you have actual mining operations in the UK, you're not really in the crosshairs. And I really was taken aback by the vast difference in the view of the UK regime versus Canada. But let me say something a little bit sobering for me. I've got this sort of head of steam about how draconian Canada is. When you talk about the wide hopper, I think you gave us the number, little over 1,000, specifically 1,079 notifications in 24-25. Only 56 called in for further review and final orders, remedy or a block on 17. I think those are the numbers you shared with us. When I looked up the Canadian numbers, they are admittedly similar. In fiscal 24-25, 1,128 notifications were certified by Canada. That was a decrease over the previous fiscal. 30 were called in, to use the British term, with 6 being either withdrawn or blocked. In fact, only 1 resulted in a block. And so that runs a bit contrary to my thesis that Canada is fully an outlier. Those numbers are quite similar to the UK numbers in the result. And so, Alastair, I appreciate you both shocking me and forcing me to take a long, hard look at what's actually happening in Canada on the numbers. Clinton, I'm going to turn to you. You've been incredibly patient, last but certainly not least. And we won't ask you to sort of explain everything about the USA or account for it. We're just glad to have you here. And again, thanks for being one of our key contacts in DC. Talk to us about the American regime, especially with the advent of what's called FIRMA in 2018. We'll be fascinated to hear your take on the technicalities of how the U.S. regime works.
Yeah. Thank you, Andrew. And on behalf of the entire United States, I'm sorry. I don't know. I don't know what to say. But thank you for inviting me, my friends at Fasken, for inviting me to this esteemed panel. And also, Andrew, for the introduction. This is the first time I've been called intimidating, at least my practice being intimidating. But I would say that my broad practice in international trade has actually been quite helpful in the sort of my considerations of our foreign investment, national security regime, and looking at how just regulations, including the tariff issue, typically more on the commercial side of things, has started to bleed over to the national security side of things, seeing Section 232 tariffs, national security tariffs being imposed on certain critical minerals. And that investigation is still ongoing. The history of the United States foreign investment regime, well, first of all, it's headed by CFIUS, so you'll hear me use CFIUS throughout the presentation, which sits within the Treasury Department. For several decades, it used to be under Exxon Florio, the amendment, where the president could come in and block foreign investment transaction for national security reasons. But the jurisdiction was really only with respect to covered control transactions, and there was no mandatory filing regime. It was in completely voluntary filing. Up until 2018, we have FIRMA, the Foreign Investment Risk Review Modernization Act. And that really, I mean, honestly speaking, has made great strides on foreign investment in the United States. Has it deterred certain foreign investments? Possibly. And I would say that FIRMA was driven, even though it's not stated publicly, driven by threat from the People's Republic of China and investment into the U.S. So the things we see now in FIRMA since the passage of it and the implementing regulations in 2020, I'll try to go through some of the similar points that we, Clem and Al, talked about. It is now has jurisdiction over basically 3 buckets. So you have the traditional covered control transaction. And when I talk about control, 10% is actually an interesting number. So if you have an investment that's 10% or less and that is purely passive, the regulations will state that there's no control there. But you could have control even with less than 10% investment, say a 9% investment, but that dominant minority shareholder has rights to veto a significant act, such as termination of, say, like a senior officer, as an example. So various veto acts, powers can give you control. That's the first jurisdiction. And that's been around for decades. Where FIRMA expanded to was covered investment and covered real estate. And I think covered real estate is of particular interest to the mining industry. But I'll first talk really quickly about covered investment. We are thinking about typically less than about 10% or less investment. To trigger that, though, you have to have a couple factors. One is one of these, for instance, board rights or observer rights. That's one way to trigger it. Another way is access to non-public technical information. And then the third one is a role in substantive decision-making. And the fourth one is, this is an important one, you have to have what's called a TID U.S. business. And so if you are going into the CFIUS process, you have to be very familiar with this TID U.S. business term, which stands for critical technology, the T, critical infrastructure, the I, and D, data, sensitive personal data. So think TikTok, right? And then the third one is real estate. So real estate it's a jurisdictional issue, and it really deals at this time with proximity issues. So proximity to sensitive government installations, military bases. And the good thing is it's actually these installations are listed publicly in the regulations themselves. So you have those three areas of jurisdiction. Let me talk briefly about the mandatory piece now. So since passage of FIRMA, we now have mandatory filings, and we also still have voluntary filings. Mandatory filings are triggered in two ways. So you have one, this one I don't see as often, is if there is a foreign government investor with a substantial interest in a TID U.S. business. Foreign government investor, that could be, I've actually dealt with some in the Canadian space where you might have, say, a government-sponsored Canadian pension fund, right? So it could be something like that, or a sovereign wealth fund from Singapore or the Middle East. That could potentially trigger a mandatory. The second one is the one I probably deal with the most, because it is primarily almost an export control type of review, where if you have critical technology, just as examples, a lot of them are in the defense aerospace company, but also industries that have dual use military and civil applications, that could trigger an export authorization. In those instances, that could trigger a mandatory filing. And then everything else falls into the voluntary filing space. I won't go too much into the various factors for that, but just as an example, if I have a U.S. entity that does a lot of business with the U.S. military or the U.S. government, that there's government contracts, that is a major factor in determining whether or not you may want to do a voluntary filing. And now today, with critical minerals being sort of more front and center, the Trump administration has already published 2 executive orders on critical minerals, one involving imports, and the other one just protecting American critical minerals. That could be a much larger factor in determining whether the parties want to go forward with a voluntary filing. Extraterritoriality. Did I get that one? Hopefully I got that one right.
Congratulations. Well done.
Thank you. This one's an interesting one, because you see that across various regulations in the U.S., including sanctions. Extraterritoriality, maybe the best way to talk about it would be sort of as an example. During the Obama administration, there was a threat to block, actually there was a block of a completely German transaction, but the German entity happened to have a U.S. branch, U.S. subsidiary, that nexus to what's called a U.S. business. So you have to have a U.S. business to trigger the jurisdiction. But between the 2 German companies, it happened that the German acquirer had some Chinese investment, and it involved semiconductors. So as you can guess, CFIUS stepped in, said, we have jurisdiction because there is a U.S. entity under the German company, and Obama stepped in to block it. Another case, which I think may be interesting, I don't know if this is similar to what Hui was talking about, but you could have even no employees, almost no assets, essentially nominal assets, but as long as there's some nexus to the U.S. economy. And a U.S. business the definition is essentially engaged in U.S. interstate commerce. It's very broad, right? So you have the case in, I think, 2022, the Magna chip case. Again, another semiconductor case, a Chinese company. But in that case, it was a Korean semiconductor manufacturer, Chinese investment, and the only nexus to the U.S. was the fact that there was a holding company in the U.S. that was publicly listed. It was on a stock exchange. And so by that sheer sort of jurisdictional reach, the U.S. was able to block the transaction, even though there were no U.S. assets, no U.S. employees, nothing in that transaction. And I have, I want to be mindful of time, but maybe I can just read off some statistics because I was very interested when Alastair shared some of his. So I was actually shocked to hear that there were potentially thousands of reviews. So I would say in the U.S., we have an open investment policy. CFIUS considers thousands, meaning to a certain extent, they look at public filings, they look at press, anything in the media, but actual CFIUS reviews are not in the thousands. So I would say the peak was maybe in 2022. Let me see if I can get my stats here. Yes, so in 2022, there were a total of 440 covered transactions reviewed by CFIUS. And that's actually dropped. The latest stats we have are from 2024, 325 transactions reviewed by CFIUS. And of those, by the way, China constituted 28, which is a significant drop from pre-FIRMA days. 49, this is 2024, 49 notices were withdrawn, 7 of which were abandoned, transactions completely abandoned. For various reasons, sometimes it's commercial reasons, and sometimes because the parties know they just won't be able to get through CFIUS. Yeah. And then just amongst our Five Eyes community, a lot of folks think, well, okay, is it that CFIUS is primarily worried about Chinese investment and other foreign adversaries? No, Five Eyes constituted 15% of covered transactions reviewed by CFIUS. So clearly very much a sort of a broad approach taken for our foreign investment regime. I'll stop there.
So fascinating, as always, to hear about what's going on in the U.S. And I will say, Clinton, one of the things that really piqued my interest on what was happening even after FIRMA came in, we all watched FIRMA closely. Our team at Fasken was examining what we would call an establishment notification by a nominally Chinese entity, and I say nominally in the sense that there was a connection to China, although certainly not a state-owned enterprise or anything of the sort. And I was struggling through this when I just happened to Google, well, what's going on in the U.S. in this regard? Are there surely the same thing is happening in America? And what I saw instead was that there were actually Chinese-owned or sponsored battery factories being built in Texas, of all places. And that really caught my attention in the sense that America has a recent tradition of being very hawkish about all things Chinese when it comes to a security lens. And yet, and I think this is a function of a cultural feature of the United States, a confidence about being able to control what happens on its territory. Presumably, the U.S. government feels that it can adequately mitigate or control the presence of Chinese investment on U.S. soil through a variety of means. And I think there's a lesson for Canada in this, even as we go through a challenging phase in our relationship with the United States. There are significant lessons to be drawn about confidence in how we monitor and mitigate even Chinese investment on our soil, to say nothing of investments that are offshore to Canada. Any comment on those battery factories, those gigafactories? And I know you if they're clients, say nothing. But if you're able to, the concept of being very aware of the potential threat posed by Chinese investment, and at the same time, a confident willingness to mitigate either through any number of structural or behavioral mitigative measures, or the knowledge that if things get rough, you can simply expropriate, which is a thing that happens even in Western governments. Any view on that, what seems like a dichotomy, but really is a feature and function of U.S. investment practice?
Yeah, thanks, Andrew, for that question. So I won't go into too many details because I am working on battery-related projects, but not necessarily in Texas, my home state. In Texas, is, by the way, it's unique, and it brings up a sort of a good point on what's going on politically, too, in the United States, because this national security regime has become more political, for better or for worse. In my opinion, you don't want to insert too much politics into national security. But in Texas, for instance, it has almost taken things into its own hands. Texas, other states like Florida, Georgia, Illinois, they are seeing, it's usually, again, Chinese investments in real estate coming into their state, and that CFIUS's reach actually isn't as far as they thought, right? I mentioned the real estate jurisdiction. It is sort of limited to the proximity issues, whether it's close proximity 1 mile radius or extended range 99 miles radius, but it has to be with respect to those specific listed installations. So Texas stepped in, this was last year, and passed their own state legislation, essentially prohibiting real estate investments by certain foreign adversaries, like Chinese companies. I think on the list is China, Iran, North Korea, Cuba, et cetera, prohibiting real estate investments. So that's kind of what you've seen, is this interesting interplay between the federal government and how the states are dealing with real estate investment itself.
Super interesting to me. I hope it is to others, but that compare and contrast just really stood out to me. I'm going to do something dangerous right now. I'm going to try to depict on screen, by virtue of a slide that we've prepared, everything you've all just said. And this may or may not work. I will give the very strong disclaimer that this is, I would describe this as a work in progress, lacking in nuance. But we have tried to demonstrate or to show the comparison of the things we've been talking about. You can see in certain cases there are caveats in a couple of places. Some of the things that stand out to me right away in row 3, definitional clarity. In Canada, in our Investment Canada Act, the test is as follows. Would an investment be injurious to national security, to the national security of Canada? Now, any person steeped in rule of law tradition will say, well, those are important words, national security. Let's scroll up to the definitional section, usually section 2 in all Canadian legislation. You can go there. You won't find a definition of the words national security. They mean what the government needs them to mean at any given moment. When I was in government, I was incredibly delighted by this. It was very, very convenient. As a private practitioner representing private clients at this stage in my career, this is horrifying because you are at the mercy of the definitional whims of the government of the day. Interestingly, Clementyne, I'll go to you on this. In row 3, Australia is the outlier. There is a definition of national security. At least we've recorded that in our chart. Can you just comment on how Australia defines national security?
Yeah, no. So I should clarify that. So we don't have it in our legislation itself, but we do. The Australian government does publish Australia's foreign investment policy. And there it has very prescriptive factors which it will consider when having regard to, and as I said, it's actually a national interest test. And it does go into the factors that are taken into account when determining what is in Australia's national interest or not. So I should clarify, it's not a legislative prescriptive definition, but it is a quite detailed foreign investment policy, and it will cover things like the impact that it has, a particular investment might have on Australia's competition, on regulatory, on tax is a big one, and making sure that investments are going to result in tax leakage from Australia. National security is a factor that's considered when they are looking at the national interest test. Now, national security itself is not; they just refer to consult partners there. There are the economy at large, employment, and what jobs might be impacted and things like that. So it's not quite a legislative definition, but it is there is a prescriptive guide or policy of the government of the day, and that actually is very rarely updated, to be honest. It hasn't been it was updated last year for the first time in a long time.
So very helpful clarification. We still don't have a legal definition, but it is helpful to have a policy. And in fairness, Canada has published and sort of modified, even in recent years, guidelines made under our Investment Canada Act, which I acknowledge have been very, very helpful in gaining additional precision. We didn't have that detailed policy, I think, prior to... is it 2022 that we saw those guidelines come in, thereabouts?
Yeah, and those guidelines sometimes shift too, right? I mean, we saw changes in the last government when they equated economic security with national security, which was something that we had been debating for a long time. So these things change over time, and it sounds like they change less in Australia than they do in Canada, it sounds like, because we have new policies that come out. I think there was a policy a year or so ago about SOEs and critical minerals, or even major mining companies. I think there was a big policy on whether or not major mining companies, important mining companies in Canada, would be allowed to be acquired by anybody. So those things shift over time, and the list that we have, while they're helpful, I think they still are fairly broad. And I think this is the same problem we ran into. I think we had a chance to work with Alastair and his colleagues at one point on a matter where the UK issues came up, and we kind of struggled with that big funnel he was talking about, because the 17 sectors in the UK, we have lists. We have the critical minerals list, we have a sensitive technology list, we have critical infrastructure list, but how they're described in there by the guidelines and the government are fairly broad. So when it gets to a point where the client goes, does this fit or doesn't fit, that becomes more problematic, and it will be more problematic for us in Canada when the mandatory notification provision kick in. We have changes that are going to come into force once regulations are passed that requires any investment of any size in certain to be specified sectors to be notified to the government. So regardless of whether or not it triggers any other thresholds for review, those will come in. And I think our thinking is that some of these lists in our guidelines will form those sectors like you have in the UK. And that's where I think it's going to be very important to get precision, because if you have broadly worded language, you're going to catch almost everything.
So let me take us just down a couple of other rows here. The timeline row 4, timelines to approval. I can't tell you the icky feeling I get when I have to look at a CEO, often through a screen like this, when he or she says to me, and how long will this take? Well, up to 200 days. I mean, this is, for the uninitiated, it sounds like a real deal killer. Deals hold together because people move quickly. Sometimes I'm shocked at how quickly people are trying to move. Breakneck speed. And when you suddenly say, yes, great, all your work is done, but it could take up to 200 days because you are investing in an area of Canadian critical infrastructure, or in a sensitive technology, or in a critical mineral property. And it is shocking to people. And equally shocking is when I look at the Australian timeline, 30 days. I realize there is nuance there, and we've tried to depict that in the chart. USA, 30 days for declarations, and then you get into a more lengthy period or potential period on notifications. And then the UK, it starts out very sunny, and then takes a turn for the Canadian as you get called in 6 to 9 months plus. It gets worse than Canada. So an interesting progression across Five Eyes allies there. Financial thresholds were all on par. Percentage of control at row 6. This is where you see Canada as an outlier, where there is no percentage of control that Canada will say, below this percentage of control, we don't care. I've never heard the words "we don't care" from Canada's Investment Review Directorate. They care. Shout out to them in case they're listening. They have really grown in their specific competence across industry areas, whereby we get asked questions about things like video games that, unless you're a gamer, you just wouldn't be able to answer them. And I've noted that the government of Canada in its industry department has really staffed up in specific sensitive areas, technology, minerals, and this is improving, I think, our collective experience. Canada Canada not an outlier on extraterritoriality. The UK is, and this is in row 7. And again, I know some exceptionality there, but that is really of interest in listening to Alastair. And then presumption of mitigation. This is one that I'll propose in advance. When we get into to our closing round here, I'll be asking you for recommendations. What ought to be done in terms of fixing or improving your own national regime? My vote will be for a presumption of mitigation, that we start out in the hope and belief that we can save a deal because we believe in the free market, we believe in the basic efficiency of capitalist principles, and we believe that we can and should be able to mitigate a risk arising. We can take this table down so we can allow people to see each other again properly. At least that seems to be how it works from this perspective. Can we go to it's our second theme, but we'll make it our closing theme because we are coming up on time, and I'd like to leave just a little bit of time for audience questions. So we'll amalgamate themes 2 and 3. We'll starting with Clementyne. I'd like to hear what works in your national investment control regime, and secondly, what's not working, and what would be your proposal for reform in Australia?
Well, apparently our triggers might be working. I mean, we haven't really touched on it today, but how the regime applies to foreign government investors, and in particular, what constitutes a foreign government investor, is a very common source of angst in Australia. Our test obviously captures the state-owned enterprises, sovereign wealth funds, but just the way that there are tracing rules in our legislation, and the way that interests held by associates are aggregated together. The fact is that this FGI test is just very, very broad and captures a lot of sort of funds and other types of investors who you wouldn't ordinarily and shouldn't really be caught. And then that has implications for sort of lower thresholds and stricter rules for those types of investors. That doesn't really work. The 10% trigger, maybe on reflection for land entities, is helpful after being a part of this discussion, but it only gets you so far. Once you hit 10%, any increase above that percentage threshold is caught. So it's not like that we have buckets of investment where you need approval to move above 10%, and then your next approval threshold is to move above 20%. Once you hit the minimum threshold for a mandatory filing, any increase in that investment, however small after that, is caught. And again, that can be a source of frustration for investors. And the 30-day period as well. I mean, technically, yes, in the legislation, the government has 30 days to approve, but there is definitely nuance there. Delays are one of the biggest complaints of FIRB. The reality is that essentially they can stop the clock, or how it works in practice is FIRB will come to you and politely request or invite the investor to request a voluntary extension of the time because they are not able to reach a decision within the 30 days. And so we do see approvals taking months in some cases. In terms of what reform, though, what is interesting and timely for this discussion is at the end of last year, the government did put a consultation paper out. I think you mentioned before how one was for the UK to invite the business world to, submit or make submissions on what could be done to improve the regime. Well, they've just done that in Australia, and they are proposing, or they did consult on some reforms. And one of the most interesting ones, and it would be a shift away from anything they've ever done before, is this concept of sort of lower risk investments, potentially moving to just away from a prior approval model and towards a notification model only with a subsequent right to call in. That wouldn't capture critical minerals, unfortunately. That's just would not be caught by a low risk investment. But that is kind of interesting, and I think that we would, as an investment community, be very open to that in Australia. Whether a notification pathway would be taken up in practice, I think, has to do with, what is that call-in period, and how much does it cost? Because the other thing to point out is that the FIRB costs are overly high, very high, and in some cases, where you've got global deals with a downstream Australian element, they can be caught in certain circumstances, and all of a sudden Australia, the Australian operations are a relatively small component of a global deal, and yet the costs for going through FIRB are significantly high and just don't sort of reflect the commercial reality of the size of the Australian business. So I think a pre-notification pathway would be interesting if there's a relatively short call-in period, so that investors can move on with certainty after that expires and the costs of navigating FIRB are lower.
Really interesting to comment on what we might call an indirect acquisition, and then the implications in that indirect jurisdiction. We certainly see that here, and there can be sticker shock when people sort of have taken Canada as a bit of an afterthought, and it turns out to be a very protracted process. It's a shock for people. Alastair, over to you in the UK. What's working, and what would you fix, and how so?
Yeah, sure. Thanks, Andrew. Look, I'd make probably 3 or 4 points about what's working. The first is that the thresholds are pretty clear, particularly for the mandatory filing. As I said, it's in practice it's 25% or more, and there are these defined sectors, and you can go away and look at the detailed legislation. It describes exactly what falls within those sectors. So I think that gives you some clarity as to whether or not you're in and out of the mandatory filing regime. That's important because the implications of missing a filing are pretty significant, because you can have severe financial penalties and other sanctions for failing to file where you're meant to. The second point is the actual filing form is pretty easy to complete. So in terms of sort of burden on business to sort of do the filing, I think the government would say, look, we've come up with a form that's relatively light touch. We could ask for quite a lot more information, but we don't, at least not initially. So that's a tick. Review period, as you mentioned on that table, the comparative table, in the vast majority of cases, it's 30 working days. So it's pretty quick. And so it's light touch and pretty quick. The last one, which I just added to my list, is the fact there's no fee. So Clementyne mentioned the fact the cost in Australia. I think the UK Treasury probably, if they're listening to this event, might start thinking otherwise. But at the moment, there is no cost on making a national security filing in the UK.
Except for solicitors' fees, and I think that might be what Clem was referring to. But point taken.
Okay, but there's certainly no filing fee. In terms of what could be improved, I talked about the hopper being very, very wide, and I mentioned at the beginning the government is looking to make some reforms, and I'm sorry I didn't cover that earlier. So what they're trying to do is a couple of things. One is to tighten up some of the definitions around the 17 sectors. They've got one sector that's very broadly defined in relation to artificial intelligence, and it captures a lot of transactions where you're using off-the-shelf AI technology. And I think that is an example where they realise they're overreaching, they're capturing too many transactions, and they're going to tighten it up. There are one or two other reforms they're going to do to the sectors as well, pulling out semiconductors from advanced materials as an example, because it's so important that it will be a standalone sector. They're actually going to introduce the water sector as a new sector, which was deliberately left out because it's so highly regulated in the UK anyway, but they've decided they think it should also fall under the regime. So they are making some reforms to the sectors, and at the same time, and I think this is the point, Andrew, where they're saying, well, we want to be good for business and friendlier. They are going to exclude internal reorganizations, which today, believe it or not, get caught. And that's a good thing. They want to reform that because that really is a bad part of the regime at the moment. And they want to make some changes to companies that are in financial distress and in certain circumstances exempt them from the regime. So I think those reforms are positive. Because the hopper is too wide at the moment. Two other points to mention. One is on the length of the review. For those few cases that get called in, the review can be very long indeed. There are prescribed timelines, but because they can effectively pause their review when information from the parties is outstanding, that makes the review potentially very long. And the difficulty for investors, particularly when we're helping them negotiate sale and purchase agreements, is how do you cover that potential eventuality of a long review? So you're pretty confident you're going to get done in 30 working days, but you can't be absolutely certain because governments are unpredictable. And so you want to give yourself that opportunity to have a longer review. And then suddenly you're talking to the sellers about something up to 9 to 12 months, which, as you can imagine, doesn't go down at all well in those sorts of negotiations. So there's a point around predictability as to how can we become more certain that you're not going to get called in and have one of those long reviews. And the third point is related to that, which is around transparency. The only cases that get published are the ones that end up in a remedy or a block. And you see a little bit of the government's thinking around its national security concerns, but they're pretty high level. And of course, the government would say, well, we're not obliged to publish and it's classified information anyway. But that is in stark contrast to, say, the merger control regime, where decisions are published very regularly. And so investors and their advisors have a much better view on likelihood of outcome in the merger control space versus the national security space, where I think it's much harder to predict. And similarly, on a very practical level, when you deal with the government, you're not allocated a case team, an individual to contact. You are really just engaging with a general mailbox and receiving information through that. So there is probably some practical improvements they could do. The final point on the wish list, which would be wonderful but isn't going to happen, despite a lot of people asking for it, is to have some sort of whitelist. And I know that CFIUS has a whitelist, and Clinton may want to comment about how helpful it is in practice. But certainly a number of stakeholders are pleading with the government to introduce some sort of whitelist, even if it doesn't mean that you are exempted from the regime altogether, but at least you can have a smoother and quicker review process where you are a known and trusted investor. Obviously, we think would be a real positive of the regime. I'm not sure the government's going to go that way at the moment, but it's certainly one that is commonly raised as being a point that would really help investors in respect of the UK's regime. Thank you, Alastair. And this idea of listing is
It is very attractive. It is attractive to know that if you hail from a country that has that sort of relationship, that maybe that gets you ahead of the game. Clinton, I'll throw to you, and then finally to Hui. What's working in the U.S. and what needs to be fixed?
Thanks. And I actually enjoyed a lot of Alastair's comments and suggestions for improvement in the UK side, because I think a lot of those could help for the U.S. foreign investment control regime as well. Let me talk a little bit about the process, because I get a lot of those questions with clients trying to figure out timing, how to get through a CFIUS review. So in the chart, we said 30 days for a declaration and then 45 to 105 days for a notice. So first of all, the difference between a notice and a declaration is the short form. A lot of people ask, well, why don't you always do the short form? Why wouldn't you go for the shorter one? And by the way, notices you have to pay a filing fee as well based on the value of the transaction. So the only transactions where I would recommend using the short form declaration are usually the low risk ones. We've done one together, I think we on prior transaction. So a Canadian investment, any investment from a Five Eyes ally, I immediately think, okay, I have to look at whether there's vulnerability in the U.S. business, and is it low risk such that I would recommend a short form filing. And if that is indeed the case, I think it is a very good process. So the declaration, you can get clearance and approval, safe harbor letter from CFIUS within 30 days. Under FIRMA, they extended the review time for notices. So let's say you have a sort of medium to higher risk transaction. The good part about that is that it used to be 30 days just for a regular notice review. For CFIUS to review threat, vulnerability, and consequence, meaning could a foreign actor exploit the vulnerability in a U.S. business, for what is the consequence for national security, that whole analysis takes a lot of time. And there's a lot of hardworking public servants at CFIUS. When it was increased from 30 to 45 days, I think that helped reduce the number of investigations that were then triggered. So, but a lot of higher risk transactions do end up going to investigation. And once you get to that point, there is a possibility that CFIUS could pressure the parties to withdraw their notice. And I've been in one of those before. It's not a fun thing to do. Withdraw and refile, at which point then you have to basically start the clock all over again. So you could end up in this sort of continuous cycle of withdraw, refile. And I think that level of uncertainty does scare investment away, that whole process. And it is not cheap. Again, I said that there's a filing fee, but of course, U.S. legal fees as well. Once you stack that on top, that could take months, right? Almost half of a year to get through an entire CFIUS review process. A second topic for what's working and what's not. So as Alastair mentioned, we do have the so-called whitelist. We call them accepted investors, and they are the investors from the Five Eyes countries. And I found that really helpful when that was announced, and I'm hoping to see more countries added to that list over the years. We'll see. And it's helped in terms of what that does is it accepts those investments, assuming you qualify, from the new jurisdiction under FIRMA, which is the covered investment and mandatory filings. So you could be exempted from mandatory filings, which is great for a lot of lower risk transactions. I would say what's not so great or could be improved slightly is how do you get an accepted investor status? I don't think we have enough time to get into the exact details, but there are thresholds for board of directors, certain percentage, thresholds for certain dominant minority shareholders, and you have to meet those thresholds in order to actually qualify. So you may have a lot of, say, Canadian companies that actually don't qualify for the accepted investor exemption. So I think that could certainly be improved. And then the third thing is something I already alluded to before. I think we're seeing more sort of the political aspect of CFIUS. Personally speaking, I don't really see that as great. I think it inserts more uncertainty into transactions when things become more political on the national security side. And in terms of improvement, picking up from what Alastair said, so under President Trump's quote, America First investment policy, he previewed that he would be making changes to CFIUS. One of those is this so-called like known investor program, like a frequent filer program where you have companies that have come in multiple times before and want to file again with CFIUS. That is actually still undergoing sort of implementation. There were comments requested by the U.S. government on that process and on other ways to improve the CFIUS review process. So I'm really looking forward to seeing how we can implement a known investor program, as well as possibly adding more countries to the so-called whitelist.
That's fascinating. The idea of a frequent filer. We do see them. We see them at Fasken. People we work with regularly, and that would be a really interesting concept. Hui, over to you in the time remaining. What's broken, and how would you fix it?
Well, maybe that's a long list. Maybe I'll start with what's working, which I think is smaller list.
Yes.
We don't have a filing fee, like Alastair said, so that's good. The other thing that's working, I think, is the voluntary process, because it allows for certainty. Because I think in the past there were this gray area where investors were saying, we think we may be in the gray zone, and if this is going to be blocked, we want to know up front. So the voluntary filing regime now allows for that. The third thing that's going well, I think, is our folks at FIRES, which is our department that's responsible for essentially mandating or implementing and enforcing the Investment Canada Act. They come from industry, so therefore I think they have a natural bias to be pro-investment, but they are the starting point for these reviews. Once the National Security Review kicks in, it goes to public safety. But I think you have a group of bureaucrats at FIRES who I think have the right mindset, and they're very good. I think they've been doing this for a long time. We have to understand that they have different pressures, because at some point these decisions become political. But I think they have a good grasp of what they can tell us and what they can't tell us. So I think over time, I think we've gotten a very good, reception from the folks at FIRES. I think that's been going well. In terms of what I would change, extraterritoriality is something I really dislike as a matter of principle, but I understand given the current geopolitical context, I don't think that's going away, because I think for you to get rid of extraterritoriality, you have to have a lot of faith in your partners internationally. You have to rely on international comedy, that you're not going to step on other people's toes, they won't step on your toes. In this environment, I don't think that is gonna play out the way I think it should. But that said, with the extraterritoriality, we're going to end up, I think, in a place where you'll see more friction. If we're telling Canadian companies not to accept investments in Argentina, in Chile, or wherever, those countries may have a different view in terms of who should be investing in their country. So we may end up with friction. And I think we saw that in the 70s on the antitrust front when the U.S. applied its antitrust laws extraterritorially against the uranium companies, right? And so we saw blocking statutes from Canada actually brought in blocking statutes. Other jurisdictions did the same. So we may be ending up in that space, but I don't think that's going to change. The one area I think that we can change, and I think this echoes what Andrew said, is on the mitigation side. Because extraterritoriality, and I've asked this question, I think if the mine is in Ecuador or wherever it is, what is Canada's interest in controlling what happens there? I think the answer we get back is supply chain, because there are certain critical minerals that we want access to. And I find it ironic, because the way it's being applied, if you don't allow for mitigation and you want to block it, that just creates incentives for these companies to emigrate from Canada, in which case you lose control over them at all. So once they're emigrated, you have no ability to influence what goes on there. Whereas I think the more pragmatic approach would be to say, you know what? Let's get undertakings, which they've done more recently, saying that let's bind these companies up to say that they will use those mines to supply Canadian interests or whatever. Use that as the hook, as opposed to saying we're going to essentially block your deal. And I think mitigation is something that the statute provides for. I think our amendments provide for it, but I think, and I hope that going forward we'll see more of it, as opposed to what has happened in the past is there's been this reaction or this knee-jerk reaction against mitigation, because the saying is too difficult to manage, too difficult to enforce. So hopefully that's where I think there's a biggest chance of improvement and probably for the better?
I couldn't agree more. Music to my ears on the Canadian side. Is there anyone there in the room with you who would have a short question? We're nearly at time, but I did say there'd be questions, so we have to honor that.
There is one question. We're getting him the microphone.
It's more a question and a comment from our U.S. experts here. The U.S. is dusting off their industrial policy tools. The war stimulation law, national stockpile on that, okay? We've all heard about Project Walt. So we're in an environment where, aside from enacting laws, where you got government as a customer and a financier. That's a powerful dynamic. I just want to hear some comments on that. Aside from these maze of laws and regulations and that.
Thank you for that. And hopefully everybody online heard the question as well, but about generally sort of the government being either the customer or financing certain deals. And I think that's true under President Trump's administration. I think he is fashioning himself as the ultimate deal maker, right? And I won't go further on that point, but I think making a deal with the United States has been beneficial to certain countries. I mean, you're seeing it not just in the CFIUS space, but also export controls, exporting certain technology to Asia, provided you pay a certain fee, a certain amount of profit, essentially, to the U.S. government. Likewise, I think that there have been, it's been alluded that there's, maybe we should have a U.S., like a sovereign wealth fund, right? And that there should be certain payments to that depending on various foreign investments. So I don't know if I can speak more to anything else on that, but I think it's an interesting time we live in where striking the right deal with the U.S. government can actually potentially pay off.
Clinton, thanks for the final word for today's panel. It is now fully 1:30 in the morning for Clementyne, and so we are going to call this thing with my sincere thanks. I don't know if everyone found this as interesting and compelling as I did. I'm biased, but this has been a discussion that I've been trying to have for a long time. I often have it with myself, which is not at all productive. This has been productive. This has been really great. And I think we've taken away a lot of the problems, the similarities, and maybe some areas for reform that maybe some of those listening will take to heart. Let me do something that I omitted to do at the outset, which is to just name the law firms involved. So Clinton Yu from Barnes and Thornburg in Washington, D.C., Clementyne Rawlyk, partner at Hamilton Locke in Australia, and Alastair Mordaunt, partner at Freshfields in the UK. And I just sincerely thank you for your time, attention, what you contributed, not only to the discussion today, but to preparation. It's just fantastic. So thank you again. And I do hope we'll see each other in person before too long. Our next PDAC session is entitled Opportunities for Indigenous Ownership, Investment, and Participation in Major Projects, a major issue in Canada at present. And that's at 12 p.m. today. That's Eastern Time. You can sign up for any of our upcoming sessions through the PDAC events button under the video window below, or by visiting fasken.com. You'll find, for those who need professional development credits, there will be a slide that comes up with QR codes for Ontario and British Columbia. And again, thanks to our participants. Thanks to those who've tuned in and have been with us in Toronto. And we look forward to future discussion on the same topic. At least I do. I think it's fascinating. Thanks very much, everyone.